Hello friends, are you thinking of getting a divorce and you got no kids and you got no property together? Well, you got no problems. That's right. Today we're going to talk about Florida Simplified Dissolution of Marriage Actions, otherwise known as the quickie divorces. We're going to cover what qualifies and how to do it. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so the state of Florida has a process called the Simplified Dissolution of Marriage Action, where both spouses can work together, oftentimes without the assistance of an attorney, and try to file for divorce because they meet certain criteria. Please keep in mind that each particular jurisdiction within the state of Florida may have its local rules, so what's cool in Miami-Dade County may not be cool in Broward or Palm Beach or Orange or Hillsborough. So make sure that if a couple is trying to figure out how to navigate the simplified dissolution of marriage process, they go down to the local clerk of their particular jurisdiction and figure out what the local rules are. So let's talk about the qualifications for a simplified dissolution of marriage action. We're going to have some links attached to this video that will have some forms, including the list of the criteria or qualifications, starting with the residency requirements. One of the spouses must be a resident of the state of Florida for at least 6 months prior to the filing of the simplified petition for dissolution of marriage. So the residency requirement can be met with either a valid driver's license, a state ID, some other form of governmental identification, or a corroborating witness affidavit. The next qualification is that the parties must agree that their marriage is irretrievably broken. The state of Florida is a no-fault state, which means that the parties don't have to give a reason as to why they're getting a divorce. They simply have to agree that their marriage is irretrievably broken. The next qualification is that there must be no minor or dependent children. That means that there are currently no minor children that were either born or adopted before the party's marriage, during the party's marriage, or after the party's marriage, and that neither spouse is currently pregnant. Meaning there's no kids around. There can't be any little kids around while you're trying to get a simplified divorce. If the kids are older or adults, no problem. And remember, fur babies don't count. The next qualification is that there are no unresolved financial obligations between the spouses. The best example is when neither spouse owns any property together, whether it be real estate or personal property like bank accounts or cars together, and they don't have any liabilities together. Neither one of them owes credit card debt in the other's name, or there's no IRS debt. That's the best qualification because neither party has property with each other and neither party has liabilities with each other. If that's the case, you are still good to go for a simplified dissolution of marriage. Next on the checklist is that neither party wants alimony from the other party. This is easier in short-term marriages that are between 1 and 3 years in length, a little bit harder in the long-term marriages, but everyone has the absolute right to choose that they don't want to have alimony. So if neither spouse wants to have alimony, you're looking good if you want to get a simplified dissolution of marriage. Up next is that neither one of the spouses is interested in what's called financial disclosure, meaning that when parties normally get a divorce, there's certain financial discovery that has to be interchanged between the parties, which can include bank statements and student loans and all that stuff. If the spouses, however, don't have a desire to see each other's financial information except for maybe a financial affidavit, if that particular jurisdiction requires it, then they're still on track for a simplified dissolution of marriage action. Next on the checklist is both spouses have to be willing to give up a trial and appeal. In that case, if neither party wants to take the case to trial or appeal and avoid those particular fees and costs, then they're still on track for a simplified dissolution of marriage action. Next on the checklist is where it may get a little bit dicey, and that is that both spouses are willing to go into either the clerk's office or an attorney's office and sign the petition for simplified dissolution of marriage together. They don't have to sign it at the same time. So if they're not getting along that great, they don't have to. But if they're getting along great, it's easier. They both show up to the clerk's office and sign off on the form. We're going to put a link to Florida Family Law Rule of Procedure Procedure Form 12.901A. That is actually the standard form in Florida for simplified dissolution of marriage actions. I know that will be helpful to a lot of the folks who are trying to find the information for simplified dissolution of marriage actions on their own. And then the final part of the checklist and the final consideration is that both spouses have to be willing to go to a final hearing, and usually that means they have to go to court together for the final hearing. So that may be a little bit awkward, but suck it up, Buttercup, because these spouses will have avoided a lot of fees and costs. Also, some of the jurisdictions like Miami-Dade County is still doing final hearings remotely, so they may not have to do that, but if they do have to go to court together, well, put on a happy face, because after that court hearing is over, it should be really quick, and they get their final judgment of dissolution of marriage. They will be happy, and they will be able to march off from that courtroom into the sunset and enjoy the rest of their lives. All right, so that is a wrap on the easy quickie divorces, otherwise known as the simplified dissolution of marriage proceedings in Florida. We're going to add the checklist of what the qualifications usually are. Make sure you double check it with each of the jurisdictions within the state of Florida, because there may be some local rules that are different. If you know anyone that may have questions about a simplified divorce or dissolution of marriage action, please have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Do us a favor and like this video. Subscribe to the Divorce Broadcast. Leave some comments, as I just said, so that we can get back in touch with you. And we wish all of you that have the simple quickie divorces all the best.